Do not publish anything more than what is in provision. So once you have applied for a okay, I have applied for provisional specification, so I'm going to publish all the documents in other journals. Okay, I'm going to disclose it only to the mark which you have already disclosed in the provisional specification. If you explain more about out of the box, what out of whatever has been explained in the provisional, and you later if you claim for getting a patent for those things, you will never get a grant for that. You can never claim that also. So you'll have to understand that you are not supposed to publish anything more than what is in provisional application. So these are the sections which comes under anticipation. So we'll have to be careful about while disclosing your idea. I hope this is very much important thing which you wouldn't have been known prior. So you'll have to keep this in mind when we have to proceed with our research work and when we are planning to seek protection for it. So process of patenting and rights. Here, define and decide your need. So as I said, what are you going to get? Are you concentrating on your career, product, prestige, protection, or sale? So these are the questions that you'll have to answer it. Next, define requirement and extent of legal support. So what kind of is your requirement? So you will have the product, you will seek the protection for it, you're going to sell it, or you're getting the license for the product. So you will have to decide upon that also. Define and decide if you need a patent search. So whether you will have to need a patent search before seeking the protection or designing your product, selling it or licensing it. Define the development stage of your idea. So this is very much important. You will have to decide whether you will have to file a provisional application or a complete specification. So it is up to you to decide whether you will have to go with that or this. So these are some of the important decisions that has to be taken. Next, what is important? Clearly draft and file the patent application. As I said, draft of a patent is a techno-legal document. So it will have technical terms as well as technology explained in legal terms, I can say. So we are going to introduce our technical or technological invention through the legal writing. So it is a techno-legal document. It has to be very clearly made. Either the lawyer will do it or the individual themselves, if they have the idea, they can do it, or we patent agents will draft for them. So publication and right. So here you'll have to decide whether your publication has to be done through early publication or regular publication. That is, early publication means within 30 days of time. The rule is that from the date of filing, within 30 days of the time, the application will be published by the official journal in the patent office. So if you want to go for early publication, okay, I'm going for early publication. I'll tell you the advantages of getting the patent application early. Once the patent application has been published, you can disclose your idea to anybody, or you can start marketing it or start commercializing it. So publication is very much important if it is got early. And if it is regular, patent office, without paying any fees nor requesting for the publication, they will publish the application in the official journal only after 18 months of time. So it is up to us to decide whether we want to get the patent early, then we will go for it, else we will not do that. So that is one of the things. Next, examination request, early or exhibited examination. So here also we have the thing. What is, you will have to decide whether you will have to go for early examination. That is, you will have to request the examination can also be request by paying the double the fees of the normal examination request. You can request the patent office for its examination. I'll tell you the timeline in the afternoon session. Like I have a chart there so you can understand very clearly what will happen in the early and the exhibited examination. As publication, I said early means 30 days and regular means 18 months of time. Here early means you all the processing up to grant will be done within 12 months of time, whereas in the normal regular one, it will take about 4 to 5 years to complete just one application procedure up to grant. Okay, but the early examination is allowed only to startup educational institutions and to if an individual, suppose for individuals, they have only one opportunity is if they have one of their applicant, if they have one of the female applicant along with them. So this is done by the government to recognize and empower women. So it was recently added in the amended law. Maybe it was done before 1 year, yeah, 1.5 years before it was amended. So a woman, if it's there in your research team, in such case you will get the way for applying for this exhibited examination. Not just money can push you to the early slot. Here, three constraints are there. Early publication, no constraint. Just by paying the fee, anybody can request for early publication. But as far as the examination is considered, the early or exhibited examination will be allowed only if the applicant is a startup, or it is an educational institution, or that applicant team has a female as one of the applicants along with them. Then we can go for examination request of early examination request. So after examination request is done, we will get a examination report from the patent office, what we call it as FER, that is first examination report. We have the time to respond to it. We will maybe 6 months of time if it is normal, and 3 months of time if it is early. So we'll have to respond to them. Once we respond to them, they will check the application and they will see what has to be done and all that. They will check and they will get back to us. Next, the patent maintenance. So once the patent has been granted, you will have to maintain it for 20 years. You can maintain it by paying the renewal fees. Every 5 years you can pay, or every year you can pay and renew it and keep it alive for 20 years. So that this is the procedure of patent application and up to filing is what I have explained. So beware of frauds and misconceptions. So this is also very important thing which we'll have to be very careful at every stage of patenting. So pre-filing phase, before filing, what you'll have to do. When you're disclosing your idea with any organization, any consultant, or any patent agent for that matter, you will have to sign an NDA with them. That means a non-disclosure agreement stating that they're not going to disclose your invention to anybody. Next, the patentability check. That is whether your research comes under the patentable matter, which will be done by your patent agent. Then the patent drafting work, patent filing. So these are the things which will happen in the pre-filing phase. Next, what will happen? Post-filing and pre-examination phase. So draft and filing application for publication, draft and filing application for examination, drafting and amending the POA. So POA is power of attorney. This is the thing which will be given on a e-stamp paper. Suppose say 100 rupees stamp paper, e-stamp paper. You will have to give authority to your agent stating that they are responsible. Yes, we are authorizing them to take care of all the aspects which are related to the particular patent application. So that is the power of attorney you will have to give to the agent. So these are the things which you'll have to take care of. Publication phase, application is published in the official gazette of the IPO. As I said, if it is early, within 30 days, or else after 18 months, it will be published. Next comes the examination phase. So FER analysis. So they will be analyzing, we'll have to analyze the FER, first examination report, and we'll have to send the response to draft and filing FER. So responding to the FER. Post examination phase, prosecution. So there will be prosecution phase. If in case the controller is very much clear and convinced, only with the report we have sent in the first FER, for the FER, that is the response to the FER, they will be happy and they will say, okay, it is granted. If in case they have some objections or they have some doubts that they need to be clarified, they will call us for a hearing. So we'll have to attend the hearing fees and we'll have to attend the hearing. Then will report by Controller General of Patents. So it will be report will be after the hearing. Report will be prepared by the Controller General. Then he will say whether to grant or not to grant the patent, and draft and filing application for grant. If it is granted, we'll have to draft and file the application for grant. So grant application has to be drafted. Then it will be grant or no grant will be decided. So post grant phase, what all can happen even after the patent has been granted. So there may be oppositions. So there may be oppositions. We call it as post grant opposition. So if some people, after you have got it granted, suppose you will publicly announce the invention and you will start commercializing it. It is maybe you're making it accessible to the public, I can say. In such cases, somebody may feel that no, this is something already related and somebody else have already claimed the patent. If suppose all these are like just examples, then they can object it and they can oppose it through sending a letter to the patent office. So it is opposition handling. So that has to be taken care if in such case, if in case there is any opposition. Else, after post grant phase, you'll have to just maintain the patent by renewing it every year or every 5 years up to 20 years of time. So this is the stages in patenting process. I guess it is very clear. So I have this session till the lunch break. What for 1 o'clock ahead I have finished. Last 10 minutes have kept it for doubts. So any doubts if you have, I'm ready to answer it now. So next session will be patent filing and drafting. It will be totally of hands-on and what certificates, forms, and everything I'm going to show. So this will be totally a hands-on session. Now we have theoretically understood the concepts. So it's time for queries now.
Thank you, ma'am, for sharing the valuable information on patents and its laws. Any questions from the participant side? Can drop in chat box. Excuse me, ma'am. There are few queries in chat box. Can you please answer?
Am I audible?
Yes, ma'am.
Ma'am, I'm
Oh,
just going
ma'am.
through the questions. Uh,
Hello.
Hello. Hello.
Ma'am, yes, ma'am. You heard audio.
So here I could see the questions regarding, is there utility patent in India? Yes, utility patent is available under IPO. What I call it as complete specification, ordinary application, provisional, all that is called as utility patent. Utility patent is when we are going to file a patent for technical advancements, then we call it as I said, method, process, all that will come under utility patents.
Yes,
Next,
ma'am.
do we have industrial? Okay, the next question I have is industrial design is a patent or separate IP? Industrial design patent is also considered as a patent, but only the wing that handles is different. Because we are claiming the configurational aspects and the aesthetic look of it. So we can understand the difference. So under utility, we are claiming the technological aspect of it. It doesn't mean that if a person says that he's owning a design patent, it doesn't mean that he don't have a IP with him. He has an IP, he has an intellectual property rights, and he has gained it for us design patent and not for utility patent. So and one more I could see is, can you share your contact details, ma'am? Yeah, that will be shared in the chat box. by our team members. You can go through it, and you can contact them anytime. They're ready to support you, ma'am. So anything else I have? Okay. What are the penalties? Once again, any consultant for patent filing, madam? Yes, sir. We have consultants, but what you will have to check on when any consultancy approaches you for filing a patent is you will have to check whether they are patent agents or not. Because nowadays we see that many people, they themselves create a group, they file it, but that such applications will not be published unless and until it is carried out by a patent agent. So, patent office will see one application, they will grant, two they will give publication, okay fine, it will, then they'll get a doubt, how come a single person can file so many patents in such short period when if it is not a patent agent. So make sure the consultancy is is owning a patent agent, or they are hiring a patent agent to work for them, and they're getting it done. So what this consultancy, what we will do is, when a person approaches us with the research work, suppose we feel that they are okay, their research work is like 90% up to the mark or 80% up to the mark, and some features has to be modified to make it patentable. In such cases, we are going to give our inputs, we are going to make them work for it, and we are going to get it done. So there is no wrong in approaching a consultancy, but make sure they are hiring a patent agent and they are working only under patent agent and not as individuals. So please make sure about it. So suppose you have given your address as your official address. No, official address in the form which will be created, always the patent office address will be specified and all the details regarding patent office will be specified. But in the official address, in the form 1, address for correspondence will be there, and that will be filed by the patent agent, and his or her name and address will be specified along with their agent number. It is very simple. You can know whether the agent is actually agent or not by asking their INPA number. You can observe in the like I can say the poster what we have created for this workshop. They, under my name, they would have specified INPA 3797. That is my register. Like doctors have their KMC number, we have that number. So under the Indian patent registered agent, you can easily log into the website. Under the patent agent, if you put my number and check, it will show whether I'm a registered patent agent or not. So that is how you can differentiate a real person from a fake agent. So you can use those tricks also.
Ma'am, sorry for the interruption, ma'am.
Yeah, fine, sir. No problem. Yes.
Ma'am, quoting me, ma'am. Ma'am, are you audible?
Yeah, sir. You are audible. I can hear you. Yes, sir.
Yes, ma'am. Ma'am, if there any further connect, you can give our company mobile number and address, ma'am.
Yeah. That's what I'm telling. Our website is www.inducenceresearchconsultant.com, and our contact number is 84-899-70504. It has been displayed even on the slides. If you note it at the in the footer, we have put it. You can approach. And for reference, I'll be typing in the chat box also. You can approach us, contact them. They will let you know all the information, like how we will support you. Even if you have an invention at the very trivial stage or a first stage, we are ready to support you and take it up to the level of patent and get it done. That is why we are called as research consultants and not the patent agent consultancies. Okay. So I could find these questions and I've answered. So anything is left unanswered, people can raise their hands or they can unmute themselves and they can ask me, I guess. Like while I'm scrolling down, maybe. I'm sorry if I missed any questions.
No, ma'am. Thank you, ma'am, for clearing all the doubts. Now we are
Yeah.
stopping here for lunch break. We will again meet after half an hour. Thank you.
Yeah. Thank you, ma'am. Thank you so much.
Welcome back, all of you. Now we will go ahead with the next and last session, which I feel will going to be really interesting because we are going to have hands-on session on patent filling and drafting. Over to you, ma'am.
Thank you all. Okay. So welcome back. Uh, hope the next session will be interesting. So after lunch, listening to theory will be the hectic part. So I've kept the hands on. So we are very clear about the theory things, like what the procedure is and all about. So now we have a few theory left out. What we'll have to just have a brief look into it for next 45 minutes or 1 hour, and then I'll take you to the hands-on session. So let me share the slides. So are the slides visible?
Yes, ma'am.
Okay, fine. So now let's see what are the rules. We not only have Act like Patent Act of 1970 to be followed to draft a patent, we also have rules which are specified from the Patent Office that was last amended in 2003. So we'll have to follow that to get the patent document in the format that is suitable to be accessed by the patent access and assessed by the patent office. So patent drafting, we have patent draft rules 2003. Rule number 9 is very much important. We have many rules, but I have just cut down the and have put the main rules which are necessary for the person who is planning to get his or her research work patented. So, Patent Rules 2003, Rule 9. So, typewritten, it should be the draft should be typewritten in either Hindi or English. So, we'll have to write only in these two languages, either Hindi or English. We'll have to write the patent document. Whatever I say as provisional or complete specification document has to be written either in Hindi or in English. Next, the minimum 0.28 centimeter letters height and 1.5 line spacing. So the document should have a line spacing of 1.5 and the letter should be, the font size should be 0.28 centimeter letters height. Okay. Then the margin. Margins are very important. So at least 4 centimeter on left and top of the A4 sheet size page and at least 3 centimeter on the right and bottom. So margin is like to the left and top, it should be 4 centimeter and to the right and bottom, it should be 3 centimeter. Then every fifth line has to be numbered. So every fifth line of your draft has to be numbered. Title not more than 15 words. So we should keep in mind when you're drafting or when you're framing the title for your research work, you should keep in mind that the title should not be more than 15 words. So many a times client will ask me, ma'am, why is this you're shorting the title? We want it, we want these words. You know what we will do? We will reframe it so that the title will explain the invention, but the words are limited to 15. So please keep in mind about this rule. And next, the abstract what we write should not be more than 150 words. This is also very much essential. If in case, but clients are not satisfied when I write, when we, the patent agents, write the draft within 150 words because they feel that it is too short to explain the concept out. For the abstract, 150 words is very much less and it is not actually enough to explain the concept. But that is not the thing. Patent office has restricted that abstract should not be more than 150 words. And if it is 150 words, the objection will be raised in the first examination report. You will, for damn sure, you will receive the objection from the patent office stating that your abstract is more than 150 words. So you will have to keep it within 150 words. No plagiarism checking. Usually plagiarism is not possible. Can somebody answer why there is no need for plagiarism in patent document? So I'll just peep into the chat box now. This question is to make us brisk after the lunch. So why plagiarism is not important for a patent document? Any answers for this? Because the idea is important. Okay, I got a response. I'm happy. So any other? Yes, very good. I got a response now from Safreen. Okay. Mama sir, it's good because idea will be novel. Obviously, this is the answer for that. Since we are drafting a concept we are writing a specification, you're explaining a concept which is nowhere already existing. If it is novel only, it is patentable. So obviously it should not exist anywhere, right? If it is nowhere existing, where will you copy it from? Where will the plagiarism come into picture at least? It is not possible at all. So it is not big, it is innovative work, it is the new work. Thank you all for the comments. It's good. It's like all of the answers are correct. So thank you. I'm acknowledging it. So we have to just concentrate on what we have to write, what our innovation is. Just write it in the way that the patent examiners and controllers will understand. So don't worry about the plagiarism, because sometimes we'll have to explain the definition in the background of invention. In there, we'll have plagiarism, because definition cannot be altered, right? Some definitions, some formulas, can we alter it? No, it's not possible. So all those are allowed. And one more thing, please don't check for plagiarism in the patent document and also in the session called background of invention. If you see the skeleton of the patent draft, what I can show you one, I will show also, but I'll explain now. If you see that, you will have various subsections will have in the patent drafting. In that, we will have a session called background of invention. Under that, we will put all the related inventions or journal documents which are already existing. I'm telling it is related, not the same. Okay, so the related documents will be putting there, to make the examiner understand that we have gone through all these applications. These are already available in the public, or the in the open access source, but they are nowhere related to the invention what we are going to claim. So this will make the controller understand that we have done a prior art. Okay, you have done a prior art, you have seen all these documents, okay, you felt it is related to, but they are not the same of your invention, and you have listed it here. So that part of the draft is very much important. And please don't check, many clients, when I draft a patent and give it to them, what they do is they run a plagiarism software on it and say, ma'am, so much plagiarized. But plagiarism doesn't come for this only. Okay, and where the plagiarism will be? It will be in the background of invention. Why it will be? Because I have put the already filed journal document abstract, already filed patent document abstract. Yeah, I have to put that and I like to explain. So please don't worry about plagiarism, and you don't feel that your whoever may be your agent or the supporting consultant research person, and they are not supported in the right way. So plagiarism is not at all required for patent drafting. So next, Patent Act 1970, Section 10. So as I said, according to the Section 10 of Patent Act, next most important requirement is that clearly defining the title and not more than 15 words. Drawing should be made separate from description. So this is a very important rule that we all should understand. In none of the patent document, the drawings should be attached with the same description part. We have two different documents. We'll have to prepare two different documents. One is for drawing, and one file is for the description. So in your description page, you should never put any of the drawings. All the drawings should be on one sheet, and the reference explanation should be in the description part of it. So please make it sure. If somebody is filing everything together, you can raise a question against them and ask that, no, this is not a rule. Drawing should be in separation. I'm not saying about tables and all. The tables and all, you can keep it here. But if some results, graphs, you have some drawings, then you put it in the drawing sheet separately. Next, these are the different fields that will be there in the draft. So first, we will specify the title of the invention. Okay, first we will specify the title of the invention. Next comes the preamble. Preamble is the thing, a specific sentence we have that has to be put in every drafting document. Okay, that is the rule, the preamble. It's a protocol. So that will be the I can say a mandatory sentence in every draft we draft. Okay, whether it is a provisional or complete. But in that preamble, we explain that the following specification describes the invention. Okay, the following, how the sentence will be is the following complete specification. For provisional, it will be the following provisional complete specification will describe the matter in detail. So this sentence is mandatory in every document. So first there will be title, then comes the preamble, then the field of invention. So what the field of invention will do? The field of invention will let you know the what field your invention is actually related to. So you are working on which field. So that is the important thing that is going to be asked there. Next, background of invention. So what is the background of invention? Background of invention is like the journal where we write the background. So already existing, so many things are there, such kind of products are there, such innovations are there, such technologies do exist, but what have I done? So what is the proposed invention doing? What is the present invention, what we are proposing is doing, will be explained in 2 or 3 paragraphs in the background of invention. Next comes the objective of the invention. So what is the main objective of the invention? Like we write the objectives in the journal paper, here we are going to explain the journal documents. Okay, sorry. We are going to explain the objectives of the proposed invention. Next comes the summary of the invention. So summary of the invention, we are going to summarize what we are going to claim. So for what is the invention? What is the problem statement? What are the solutions to the problem statement? How are we achieving it? How efficacious is our results? And all such things will be explained in the summary of invention. Brief description. So brief description is used to briefly describe the drawings. So I said none of the figures will be placed in the same document as that of the description. So since we are placing the drawings or descriptions in a separate drawing sheet, we have to put the reference under this brief description. This brief description column is meant to write the just to give the title. So figure 1 illustrates the this one, figure 2 illustrates such and such drawing, figure 3 illustrates the graph, okay, something like that. So that brief description will be coming under the brief description part of the patent document. Next comes the detailed description. So detailed description will be explaining the invention in detail. So here in the detailed description, you will explain the interaction between various units, various components, or various, I can say various components of the invention, whatever you are going to claim. So everything in detail, what is happening between this component and that, what is this component, what is the I can say, okay, what this component is actually made of, and what is its advantages, what are its properties, and all such things will be explained in the detailed description, along with the explanation to the figures or drawings that are put under brief description. Whatever you have put under brief description will have its complete explanation under the detailed description. Next important part of the patent draft is claims. So we should be very much aware about the claims. Claims are the part which will be thoroughly examined by any of the examiner or controller of the patent office. Why? I'll let you know. Because claim is the part where we are going to claim what the proposed invention is actually doing. So we are going to claim, okay, this is what my invention actually claims for. This is what my invention is going to look. So suppose I can say we have developed a new smartphone, and you are going to claim a patent for it. And how your claim will be is, you will say that the proposed smart mobile phone includes a voice recognition unit, wherein the voice recognition unit will listen to the voice of the owner, and it will grant access to the important documents or important applications of the mobile phone. This is just an example. So it will have to explain each and every part, whatever you have introduced, each and every component or unit which you have introduced in your invention. Take those units, explain what their functionality is, what is their advantage. This is the claim part. So your entire invention, what you have explained in detailed description, will be explained in claims again, but not as paragraphs, but as points. So claims are very important, and government, the IP office fee schedule has been fixed. Up to 10 claims, we have some fees. After 10 claims, every claim has a separate fee. So up to 10 claims, it is allowed for the standard fee structure. And after that, for every claim, if you have some more claims after 10th claim, for every claim, it will be charged by the patent office accordingly. So, and one more important thing I can say is, when the grant is granted, the grant will be granted based on these claims only. So how the controller will write the report, I'll say, suppose in the claim 2 you have explained a component, and claim 3 you are explaining a component, and claim 4, if the controller feels that it is already existing, the component is already existing, but 3 and 4 are the only unique part of your invention, it is not that the patent is not granted. He will grant the patent, okay, and 2 and 3 claims are granted. But if you say to a person that you're granted, you need not have to explain a person that no, only my second and third claim were granted. That's not the thing. It is the internal thing which you have understood, that I have got grant for the feature, second claim and third feature, what I have explained in my invention is what I have got the grant for. But for the prestige or recognition purpose, you need not have to say people that only my second and third claims were got granted. No, you just say that you own a granted patent. So we will just say that we own a granted patent is the most important part. As I said, abstract will be the last part. Unlike journals, where we write the abstract first, that is not the case with journal documents, sorry, patent documents, where we write the abstract at the end after claims. Everything has been done. The last part will be the abstract in the patent document. So, okay, now you've gotten I just say that, okay, rough skeleton I have given now, how a complete specification document should be, and where we are going to put the drawings, what are the rules we'll have to follow. So I hope now you all got a very not okay I can a brief idea of how to approach for filing a patent. So can I consider the answer to be yes? Or anything else I have here? The chat box is open. I can view, I can answer before moving to the next thing. If there are any queries, I'm ready to answer it now itself. Because at this time, maybe you may get some doubts, and at the end of session, you may forget it. So now if you ask, it will be cleared here itself. So any doubts you have? I'll wait for 2 minutes. Okay, so I'll proceed. It's done, I guess. So the most important thing this chart is explaining is the timeline, because everybody will have this. We have explained everything, the procedure, everything. So what is the timeline and the flow chart of how the Indian patenting process timeline? So how it is going to take and all that. Okay. So here I have got a question from one of the professors, where we find patent documents for reference which already run. The patent documents for reference, we will find it on WIPO, World Intellectual Property Organization, but you'll have to get a login for it. Mostly the patent agents will have a login to it. Apart from that, like normal patent search, you can search it from Indian website. That I'll show when I take into the IP website through in our hands-on session. There I will show you where we can find the already published patents and refer for our like it's just for reference. We can find it there, and I'll really let you know when I go into the hands-on. I'll keep it in mind. Okay. So let me come to this Indian patenting process timeline. So establish priority date of the patent application. So you file, you get the patent application. Okay, if it is a provisional. Then you file a patent application in India, request the early publication. It is optional. If you want early publication, yes, you will request it and it will be done within 1 month of time. If in case it is not, then after 18 months timeline, which you can see here, the patent will be published. It will be published after 18 months of time. So here it is. Okay, so otherwise the entire process will take 48 months, and after 18 months, this will be published. The publication will only take up to 18 months. So once the patent application has been published, we can request for examination. Please keep in mind that as soon as we file the application, immediately there is no way to request for examination. The request for examination can only be approached only after we get the publication of that particular patent application. Only after a particular patent application has been published in its official gazette, we can request for examination. So many clients will ask me, ma'am, at the time of filing the application itself, can you just request the examination? No, it's not possible. Only the published applications are eligible to be requested for examination. So after publication, request for examination. So examine of patent application will take place. Is the patent application in order for grant? Okay. Then they will issue an examination report will be receive. We will receive it. We are supposed to respond to it within 6 months of time. And again, within 6 months of time, we will get to know whether the patent is granted or not granted. So until then, so entirely like 48 months of time is roughly around 12 fours are 48. So 4 years of time we will have to give if we are filing a normal application and waiting for the grant. Please keep in mind the process will take up to 4 years. It is nothing to do with the consultancy or the patent agent or a person who is supporting you legally. It is all with the patent office. So they'll have to give communicating us with the examination report, with the response and all such things. Only after receiving all that from them, we can proceed further. So this is the thing. If it is, as I said, if it is the exhibited examination, that is for the startups, educational institutions or women applicant, one of the applicant is a female applicant, then we can have that faster procedure and get the grant, try for getting a grant within 12 months of time. So this is about the timeline of the process. So I hope this is clear. So let me move on to the next slide. So various forms. This is also very much important, which we'll have to keep in mind. Various forms that has to be filled while we consider a patent application. Form 1 is the application form that will include all the details regarding, please keep in mind, these are the essential forms. Actually, there are around 30 forms in patent office. From form 1 to form 30 for various, sorry, they will serve different purpose. Okay. But these forms are essential to be filed by any person when he files an application, he should know the meaning and purpose of these applications. So I'm just from 30 have chosen only these forms because these are very like it is the need for the normal person to understand. So it is enough for you people to know it. So form 1 is the form like application form you are filling in either for the provisional or complete specification. You are going to select in the form and you are going to enter all the details of who will be the inventor, the applicant address, who is your agent, your other thing, your title of invention, how many pages your complete specification has, how many pages your drawing, how many drawings you have, how many pages of drawings you have attached, what's your abstract, and all that will be included in form 1. What about form 2? Form 2 is the complete draft. What we are supposed to submit to the patent office, the draft which is explaining your invention, the draft which is explaining your innovation or invention is form 2. So it will be either the complete specification or the provisional specification. And the format is as explained in the earlier slide. That is, it should include field of invention, abstract. I said no, that will be the form 2. Next comes form 3. Form 3 is statement and undertaking. That means you clarify that we have not filed any patent or any, okay, we have not filed any patent for the same concept outside India or in any other patent offices. Okay, so this is what you have to declare, that this is the first time I'm seeking the patent application grant from this particular Indian patent office, and for the same application or same idea I have nowhere filed the patent. That is what is form 3. If in case you have filed a patent already outside India, please utilize this form to fill in the detail and state that, okay, before 6 months I had filed, before 3 months, date of filing, and what is the status in that particular patent office. Suppose an Indian a national has first filed a patent application in German patent office. He has to specify that on so and so date I have filed for the same concept. I approached for protection in German patent office, and this is the status of my application in German patent office. Please specify that and let them know. Here, one very very important thing I want to share, which was in the Indian market maybe last year or maybe 8 to 9 months ago, I guess. Yeah, last year. Regarding the Australian patent application, people were falling prey to it like anything because they wanted to get the patent application done. International application is a big thing for us because we are just learning about what is what is a patent and all that, and how to file a complete specification. And for us, getting an international application is big thing. So it is a great achievement. What people did when they saw that, okay, Australian application is getting innovation application is getting granted within 3 months of time, people were rushing to it. But what they didn't consider, they didn't check whether the person they are approaching as actually a contact in Australian patent office. Okay, are they moving through a patent office? I, being a patent agent in India, recognized patent in India, I myself can't file international patent without engaging with the patent agent who has registered in that particular country. Suppose if I want to go for US patent, I'll have to tie up, like through our associate, I can say. We should have association for with the patent agent who's working in US to apply for the international application. I myself individually can't do that. You know what these people did? And one more important thing, we have to, under section 35 of Patent Act, we should request the patent office, Indian patent office, that we want to file Indian like international patent. We want to file such and such idea. You'll have to give the abstract. See, what is the rule? You'll have to specify the rule in the form 25. Okay, in form 25, you'll have to specify the title of the invention and the abstract of it, and say and request the Indian patent office that, dear sir or madam, I want to file for the same application. I want to file international application outside India. Can I get a permission for that? You'll For that you have a separate fee. You'll have to pay. Wait for it within 30 to 35 days of time. Yes or no granted permission will be released by the patent office from the controller. Later, once you receive the permission, you're ready to get it filed in that particular country. And again, you want for the same application, you want to file in the some other country, you can file. Since you have got the for foreign you have got the foreign permission, foreign filing permission, we call it as FFP. So you have got it already. So you can, any other country you can move without asking. Once you have to get the permission. If in case you don't want to get the permission, you don't want to follow that form 25 procedure and get the permission, we have one more rule also. What you can do is first file the Indian application, wait for 3 to 6 months, or sorry, wait for 3 to 6 weeks. Okay, anytime between 3 to 6 weeks. Like once it is published, you can process, or you have to wait at least till 4 weeks. Okay, after 4 weeks, you can go for filing the international application. This is also possible. In this way, you will achieve two things. At the same time, you have filed the Indian application and got it granted, and you got it published, and you are approaching for a international application. This is one of the way. Please don't fall prey to such consultancies or such persons who are saying that we are going to get, okay, Australian innovation patent was there, even I have got it done it for my clients, but how I did it? I took for permission from the Indian Patent Office. Then I got it filed in Australia through my Australian attorney, my associate. So this is how I got it done. So there will be no objections. No case will be filed against it. If in case you are filing a foreign application directly without taking permission from Indian Patent Office, the rule is the person is eligible to be behind the bars even for up to 3 to 4 years, minimum 2 years, or fine up to 1 lakh. So this is there actually. So we'll have to be very careful. So since patent is not just the technical aspect, it is all related to law. So we should be very clear about the legal terms and what patent laws are saying. So please, whenever you have any confusions, please consult somebody and then you can start doing it. So it's not that there are many genuine people also, they're getting it done. It's good. You know what, they have an agent with them. They even I have many clients who approach like that, and I'm facilitating them as consultant, many consultancies. What they do is some research work is stopped in between, so they take up the inventors, they ask them, they can work with them, they fill in the positions and they give it to us for filing, and we get it done. If they are really applicants, there are no legal flaws in it, we can file it. So please check that the person who's going to file for you is an agent. That is very much important. Next, Form 5 is declaration of inventorship. This is to declare that we are the first and true inventors of it. So we are the inventors. We have all the rights on the patent application which we have filed. So that is Form 5. Next comes the Form 9. Form 9 is the form which is used for request for early publication. So the purpose of Form 9 is to request for early publication. As I said, if you are interested and if you want to get it published within 1 month of time, you will have to go for Form 9. Next, we have Form 18. Form 18 is for request for examination. In Form 18, we have one more variant which is introduced since 1.5 years. As I said, that exhibited examination. So Form 18A will be filled only if you are going for express examination. Otherwise, if it is normal examination, it is Form 18. Next, Form 26 is power of attorney. As I said, you will have to give a authorization to the patent agent specifying that he or she is the authorized person to take care of all your patent activities. So that will be given on an e-stamp paper and it will be applied under Form 26 in the patent office. So next we have Form 28. Form 28 has to be filled by small entity or a startup to or an educational institution to say that actually the applicant is an educational institution. Okay, so the applicant is a startup. Just to say that, so for a startup, I can say you have to upload your DIPP certificate, which will be issued from DIPP stating that you are a startup, your recognition certificate, I can say. So that you will have to upload, because why that is all essential is we will claim some benefits out of it. If you are an educational institution, if you are a startup, or if you have a female applicant, we have many, as I said, some concessions we have. So to obtain it, we'll have to prove that we are that. So to prove that we are having that, Form 28. So these are the important forms that has to be filed, and we have to remember only these five forms before going for getting a patent. And only if you are interested with application, just concentrate on Form 1, Form 2 and Form 9. Rest all comes only after examination and publication is done. Okay. So, and Form 3 comes into picture if you are going to file the same application which has been filed outside the India or some other country, and you are seeking permission in a new country, then it can be done like that. So, I've explained about forms also. So, any clarifications you need till now? So, I'll proceed with the next slide. So, here this is the application form 1. You can see, okay, have just put it here to make everyone understand how the actual form will look like and what will be done. So patent Form 1, see, it will specify the Patent Act 1970 and patent rules 2003 has been followed for this, and applicant's reference. So you will have to select the type of application here. It will be ordinary application. Okay, and see, we have, as I explained, everything is here. PCT national faced convention, divisional, patent of addition, everything is here. So just click watch what you want, proceed. Then the applicant details, name of the applicant, nationality, country of residence, and is the address. So in this category, you have this. So you can see the category of applicant, whether it is a natural person, as I explained, small entity, startup, or others. All this you'll have to explain. Now we have in the new form, in the online e-filing form, we have got one more option which will say for e-filing. Okay, so for e-filing also we have to look for it. Provisional or complete specification. So this is Form 2, as I said. So this preamble, I said, no, we have the preamble of the description. So, okay, I have a query here. Please don't mind. I'll just answer that. Can I apply patent for my PhD thesis work? Yes, sir, you can. We can apply for patent based on your PhD thesis also. So the following, this is the preamble for provisional specification. The following specification describes the invention. here for the complete, the following specification particularly describes the invention and the manner in which it is performed. So what is the difference is we are explaining the manner in which it is performed. That means we are explaining the entire procedure, but the provisional specification we are not doing any thing, like we are not attaching any what I can say is working principle. Yeah, how we are going to do it. So that is the difference between the preamble of provisional and complete. This is how your form 2 will be. Okay, abstract claims I or we claim. I means in a single applicant, we means there will be multiple applicants, and all that for we have to consider. So here's a question. So patent for MPhil thesis, ma'am. Ma'am, if the thesis has the inventive step or innovative and it has patentable matter, any thing is feasible. If it is technically advanced, we can go for filing a patent even for that. And one more query I have from Lokesh sir. Ma'am, where do we get all these forms? Sir, all these forms will be in the patent office login, and a patent agent will have access to it, and we'll have to do that. We'll have access there, we'll log in, and we will get it done for you. I can show you. I will personally log into my login, maybe another 10 or 15 minutes, maybe maximum I can take 20 minutes. That's it, not more than that. In 20 minutes, I will log into the session like IP website, and I show where the forms will be, how we are going to fill it up, and all that details I'm going to give. So this is statement and undertaking. As I said, what we are going to say here, we have not made any application for the same or substantially same invention outside India, or we have made. Okay, that is what is the form 3 for. Next, form 9, request form 5. Okay, form 5, let me explain. It is inventorship if required. As I said, see, if I put if required, it is not mandatory. So why it is if required? Only if you have filed, you will have to do this. And declaration of inventorship is required. This form is very much important. Before going to examination, this has to be filed, but not at the stage of getting the patent published. Until publication, Form 5 is not required. So Form 5 will state declaration as to inventorship. So this has to be given by all the applicant and inventors. Okay. Next, request for publication. If required, early publication. As I said, if you want to request for early publication, then only you are going to put this. Okay. So I have got a very interesting question here. What is difference between patent attorney and patent agent? Ma'am, patent attorney is the person who's a lawyer. Like his background is law, and he has completed the patent agent exam. We patent agents are, we have technical knowledge. It's like my background is like technology, right? I have my master's in technology and I'm pursuing my PhD now. So I'm a technical person and have cleared the patent agent exam. So I'm a patent agent. I'm having both the knowledge, law as well as the science. But attorney is the person who is a lawyer by his profession, from his education. He has studied only law from his bachelor's to master's and whatever it is. So he is a pakka law person, and we are both technical and law person. So that is the difference between patent attorney and a patent agent. Okay, so request for publication if required. Early publication is like you will have to all these details will fill in, and we will request the controller that her application has to be filed early. Sorry, published early. Next comes form 18, request for examination. As I said, we'll have to fill in these details, and request for the examination has to be made. This is form of authorization of patent agent. This is very clear that we will have to say that we hereby authorize so and so person to act on behalf of us in connection with the request that all notices, requisitions, anything and communication thereto will be to that person is what is we are going to declare. So this is form 26 to authorize a patent agent. Okay. Next, proof of small entity or startups. So form 28, here we'll have to, as I said, this is for making clear that whether we are a small entity or a startup. So you will have to enclose. What you will have to enclose is the document which states your registration. For an Indian applicant, evidence of registration has to be any evidence which claims that you are coming under that category will has to be attached to claim all the benefits for being that kind of applicant. So these are different types of forms we have understood. Okay. So, and one more thing, there is no difference between patent agent or an attorney. Both are going to work in the same way. All our responsibilities are same. Only it's and one more thing, it is always better to go with a person who's both technical and who's having a knowledge on legal rights of patent. It is not like since I'm into it, I'm not saying it. You can understand if I say this example. Suppose if you just go to a person who's only into law, will he be able to understand your invention or innovation to that extent where a technical person can understand? There is some difference in it. So we have to do that, and you will understand it when you approach a patent agent. Say, on a call, they sometimes they will understand what you actually want to do and what your invention is. So based on that, you can select and you can go forward for filing your patents. So this is sample published patent. So it was just C17 one we have filed and we got it out on 21. So this is, I'm the applicant of it. It is my invention. So I'm the first applicant of it. So this is what we have filed for. On 17 one we filed and we got it on 24 one. So I guess it is just a matter of, okay, 6 or 7, okay, 8 days we have got it. So this is how the published document will look like. So this is the grant certificate. This is how the patent granted certificate will look like once it is granted. This is published. This is granted document. So this is what is the difference between the patent grant and patent document. So I have few questions. So before taking into the website, I'll just answer them and I'll get back to the online session so that it will be clarified here. Okay. Okay. MSc chemistry student and PhD. Am I able to be a patent agent? Yes, ma'am. You have to. When they call for the patent agent, you have to apply for the examination. This year it's already done. Okay. The exam will be of in 3 sessions they will do. So they will be calling only 3 or 4 years once. And the examination will be conducted only at 4 places in India. That is wherever the patent offices are put up. Like for South, we can go to Chennai. That is the nearest for us. So for South people, accessible is Chennai. And the other patent offices like Mumbai, Delhi, and Kolkata will be conducting the patent office exam. And it will be called 3 or 4 years. And you will have to keep checking in the website. Last it was called 2018 and only 2022 they have called and the examination is done. In the month of May have done. Already the list of selected candidates are announced, but they are waiting for their interview. Only in the interview and bios they are selected, they are patent agents. So that is there. So you can apply, ma'am. Okay, ma'am, if anyone is. If anybody misuse the of my own work get patented means how will I get claim? So it is like we are going for patent to protect it from somebody else misusing it. Okay, if in case they are misusing it before getting grant, okay, then you have the priority date already in the patent office and you can claim for it. I have applied on so and so date itself and he is the person who has copied before it. So you'll have to prove that you are the first and true inventor of it. For that you may have some results, some laboratory experiments if you have conducted, if you have recorded your results, some email proofs, and all such things can be used to show that you are the first and true inventor of the application. So that is what I've answered. I published patent but not received certificate. For publication, you will never receive any certificate, ma'am, also for the question. So somebody is saying that they have published a patent, haven't got a certificate. No, this certificate is only after grant of a patent. That is, you will have to process up to examination and grant, then only you will get certificate. This is the sample I have taken from the official journal of patent to show that this is how it looks like. So every Friday, I'll let you know one more thing. If somebody says that your patent is published on some other day other than Friday, please don't believe it. Because patent office will release its journal only on Fridays. It is a rule that Only on every Friday, the patent journal will be published in the IP website, and from there you can, from the journal you can download and you can take a screenshot of it and keep it like this. No certificate will be given. Only thing is you will get this journal document as a proof, as well as you can in the status you can check whether your application is filed or it is published. That also I'll show you in the login session. So that can be done. So this is how it looks like. Okay. I hope I answered all the questions. Okay, so we have a question here. Very interesting question. Examination means in which way it would be. So examination in the sense, sir, whatever the complete specification we have filed, that will be analyzed. Like your journal document will go for review, right? In the same way, this will be reviewed by the control examiners. Examiners are who again? They are not lawyers. They are the technical persons, scientific advisors who have been hired from the patent office. So they will examine your application and they will generate a report, and that report will be sent to the controller. The controller will again go through your application, and he will come out if he don't understand anything, if he feels that he requires more explanation, and if he feels that some documents already existing are related to the patent, he will give out a list of documents. Okay, and he will say that these are the things which has to be published from us. If you want, I can show an FER copy also. One second. I'll just minimize it. Is my desktop visible?
Yes, ma'am.
Okay. So this is how the FER looks like. My screen is shared, right?
Yes, ma'am.
Okay. So this is how the FER will look like. So this is one of my clients thing, what have got from patent office. So it will explain the deadline within which the application has to be, like we'll have to send the response within 28/2 of 2022. Okay, no, it was issued on 28/2, sorry. And we'll have to respond within 6 months of time. Okay, we'll have to keep it in mind, and it will expire from that day. From within 6 months of time, we are supposed to file the application. Okay, it was published on 25/2. It was filed on 28/1. So based on this, here they have listed some documents. Okay, they feel that these two documents which are already published, it looks like relevant to ours. Okay, that is what they are claiming, but we have to defend that it is not the same. So I have prepared the FER report stating that this is not the same, and these are some of the okay, these are the explanations for those documents. They have given what D1 is doing, what D2 is actually doing. That is what they have explained, and the sufficiency of disclosure, what we have disclosed, if they have any things like claim has not been drafted properly, and what are the documents we have already submitted, that documents that are on record, and all that will be listed, and the controller's name will be specified here along with the location of the controller. So the last date for examination is 8/9. So this is how it is. This is the examination report. Once I respond to this examination report, I will be getting the response from the patent office. I have prepared the response also. I can show. So this is how I have prepared to the respected controller. I have prepared it. So this is how the document will be. So still it is not complete. It is under still all verifications, and little more work is remaining in this. So after I put this, I'll submit it to the patent office. This is how the FER response copy will be. So once I respond, he will again go through this explanation what I have submitted, and still if he has any doubts, he will call me for a hearing. So for the hearing, I'll have to attend the hearing and I have to clarify his doubts. Then his decision will be either granted or not granted. And it is the sole decision of the controller. Nobody can do anything for that. So I hope the examination process is clear now. Sir, I guess your question has been answered. So let's go into that. So this is the IP website. I hope it is visible. So this is the IP website. Okay. So all updates, as I said, the result for patent examination has already been announced and they're calling for the Viva Voices. The schedule they have displayed it. And like that, we have list of candidates selected for Viva Voice. So also whatever important things will be there will be listed here in the news and updates. And events will be listed out here. Journals. So journals are, I'll let you know. Let us go there. So journals, we have patent journals, trademark journals, and geographical indication journals. What are these journals? These journals are the documents in which you can find your published application. So it will take you to a separate website. So in this, see, every Friday, it will be released. You can see the date. Only Friday. So 7 days gap will be there. Every Friday, you will have a thing released. And this part 4 is designs. That means in this, you will find the granted design patents. So in the part 4, you will find the design patents, and part 3, part 2, and part 1, you will be getting the official journal of patents, and inside that your published applications will be there. So this is how you find it. Okay, journals are done. So here public search is there. So when servers asking how to check the status, where to go and check for the patents, all that you will get here. So public search, if you go, if you enter the field of application, what you are looking for, okay, if you fill in this form and enter the captcha and give, it will list out all the patents that are related to that specific title. Okay, everything will be listed out here. So this is one thing. And here in the same page, patent search is there, e-register is there. So if you put your patent grant number, it will show your registration and your certificate. Application status. Somebody said, ma'am, my application has been published, but I didn't receive any certificate. So for that thing, you can do one thing. Here you can just enter your application number and you can check whether your application has been published or not. One second, I can, for example, I can put some number and I'll show you if you want. Just 2 minutes of time. Sorry, IP server is slow, so you'll have to bear with me. I'm so sorry for that. Okay, there's a question here. Till then, I can answer that. Before publication, can we check its status? No, sir, you can't. You can check. What it will show is application has been filed. So see, email is my email ID because I'm the agent for this. So I have published it with 12 inventors, applicants, and as well as inventors. They are the same. Okay. So the publication date also you can see. Under section 11A, it has been published. The field of invention is chemical because it comes under chemistry. So this is how the status looks like. So awaiting. So here, sir, I can show you. There's a question. After filing, will I get to know the status? Yes, it should show as filed. Only this filed part will be darkened with green color. Only if it after publication, it will show this. So RQ filed means request for examination filed. If the request for examination has been filed, this will also be covered up. And once this is done, it will show as under examination. Oh, this under examination will be listed from the time of sending the FER, response, hearing, everything. Only after whether it is disposed means whether the grant has been given or granted, we will get to know on the disposed this icon. So this is how we can check for the status. So it's done. Okay. Same way you can search for designs also. Oh, I said if you want to register, check for your patent agent, whether they are patent agent or not, you can just check there. So I can put my number. See, it's showing my name, and I register every 3 years. I will renew my thing. You can renew it. So I have renewed just for 3 years, and it is showing 982 days left for me. So after that, I'll renew it again. So I've continued up to 2025. So this is how you can check your application. So sorry, your agent, whether they are agent or not. Ask them their number and check it. You will get to know. So here's a question. Okay, nice. What is the meaning of ordinary application? Sir, ordinary application is the basic application which you're filing is ordinary application. So yeah, why is it called as ordinary? Is you're not going to claim any international things on it. So you're not filing a international application. You're not filing a conventional application. You're not filing a divisional application. Means already one application has been filed, and for that you're not attaching anything. So in such case, it is called as a normal application. First time your research has been requested for patent. So that is the ordinary application. Normal one. Complete or provisional will come under ordinary, and there you are supposed to check whether it is provisional or complete. That also I'll show you now. Okay, so that is ordinary application. One more question I have. So many of them are filing patent without patent agent and patent attorney. What is the difference? Sir, you can file. What they do is, or it is not a procedure actually. Sometimes the patent will be held up in the patent office. I have seen the cases. Okay, actually, patent agents are the persons who are authorized to do it. Why is government taking so much of a risk in conducting the examination and certifying only the persons who have knowledge on patents to be the certified patent agents to practice it? Because we know what patent's importance is. Patent is not just an individual's asset, it is an asset for the nation. So when you our invention, whatever we do is the asset for our nation, not just for us. So government will be very keen about it, and we'll have to understand what it is. So that is why it is better always go through a agent. So you'll have a formulation. I'll tell you, many people they have lost their money, they have come back to me. They say that okay, they said they'll file. Yeah, they filed. Application has got stuck in the patent office. It has not been released because they found out that it is filed by somebody else, not the agent. Because we'll have a digital signature, we have a login. So only the person who have the registered DSC with the patent office will be able to do it. Okay, what they do is e-filing we follow, and in DSC we have option. Sometimes they go for physical filing and they think that even individuals can haram say do it through physical filing, but that is not the way. Patent office will find out at and somehow they will find out and then just stop the application. Your money is wasted. It is not going to be processed further till publication also. So it's better you verify the person and you go for it. Okay, I have a question here. Before applying for patent, where to check whether the idea we have is already patented elsewhere? Ma'am, this is where the patent attorney or the agent will come into picture. For the previous question, somebody had asked why can't we file it for by ourselves. So here the answer to it is here, very clear answer to his here, because the patent agent, as soon as he sees the concept, he or she will understand whether it comes under the patentable subject or not. We will search for the patents, the entire database. We have the login to the global patent office as WIPO. We log in, we check all the patent documents, and we will say whether it is already existing or not. We will give the report to you also. To the client, it will be disposed so that even they can understand where their invention is. You know, for a okay, suppose every invention is like a baby to the inventor, because he or she would have given us full to bring that invention out. So they always have a belief that their invention or their research work is outstanding from others. But as a patent agent, I see it as a third person. So I will have always flaws, and I will just look for flaws in it. I'll always look for the disadvantages in it, and whatever is the negative aspects of it, I will dig into. Why I do that? To make the concept strong, that nobody else for the next 10 or 20 years should be able to copy it. They should not be able to copy it, or they just can't recreate it. So we should think to that extent. Writing a patent draft is there the agent stands, because don't make the drafting very narrow. Always give a broader scope to it. Always try to fence as much as possible. Because if you know that, okay, suppose I have invented a product which is just useful for, just as example, I'm just giving, just to clean the floors. Just make it compatible to clean the glass, everything, vehicles and all that. Just make it broader, because always it is better to draft the patent with broader sense and not to narrow down the concept, because you'll have a much greater thing. So this is the difference between when you go for a patent agent or a patent attorney. This is what they do, and they will make a very clear report on prior art, and they will give the documents to you. There, the advantages of, I'll tell you the advantage of studying the prior art report. Once you study the prior art report, you will get an idea like what is positive, like and what the others have done. Okay, they have already solved the problem in this way. You will get an idea to modulate it. After reading the documents, you may get an idea to modulate it, and you can change that into a positive solution. So there are much advantages in it. So make sure that you get a prior art report. Ma'am, the question as the answer for that is you will have to get a prior art report done for your research work. So next question I have is from Dr. Sarojini ma'am. So madam, would you please tell about RQ file? Ma'am, RQ is the request. The status what you have seen there is what you're asking about. I got to understand that. So RQ is request. So whether the request for examination has been filed or not. So only after publication, you have the right to ask for whether we have to file for the application or examination or not. In that, you will do that. Okay, I guess it is clear. So I'll just keep moving to the next part of it. So public search, I showed how to search for patents, and trademarks are here. Designs the similar way, and the status here. Actually, here also you can do in status also. Directly, if you go for patents, the status. See, as I said, application status, same thing here also. E-register, application status. You'll have to put the application number, and you will get a whatever the details you require. So here you can see somebody will get confused. So this query also I wanted to answer actually, because many will have a doubt. Ma'am, here the application number format is like different, 9894/DEL NP/2007. So this was the earlier format. Okay. Before 2000 2015, we had this kind of format. And from 2015, the application number will start like, I'll explain you. I'll put the number here and I'll explain so that you get to understand. This is just a random number I'm entering. Okay, what this specifies? This 4-digit will specify the year of filing. So any application filed in 2022 will be 2022. And this 21 is the code for the patent office. Suppose the 21, it is 11 means it is Delhi. If it is 21 means it is Mumbai. If it is 31 means it Kolkata, and 41 means it is Chennai. So these are the digits which will explain the application, which application, which patent office your application has been reached to. Okay, so you can look at it and you can analyze it. So these will be the application number actually. So the year 2022, then comes the patent office digit. Okay, 1 2, and then the application number. This is how it will look like. Okay, so next. Status is done. Here you will get the expired patent list and disposal of patent applications and all such things. The controller's decision you can get here. The registration of the patent registries you'll get. Okay, here this is the important part of it. Now you can, sir or ma'am had asked me previously, where will we find those forms, ma'am? From where can we file those patent applications is what they had asked me. So let me just dig into it. E-filing of patents. This is the login page. Okay, so I will log in here. So this is how the real page will look like. So my name is here. Forms are here. What all I'll do, the form history already, what all forms I have drafted. So whatever forms I have drafted will be here. And here make payment or submission. So I'll have to make payment for these applications. So here discarded forms will be displayed. Quick form filling. If you go for new application, this new application. So here we have something called NBA. Let me explain it. You can see here, go to NBA website. What is NBA? NBA is National Biodiversity Authority. Okay, suppose if your invention is based on any research or information on a biological resource obtained from India, prior approval of National Biodiversity Authority is mandatory for the patent. So you'll have to, why this is essential? Suppose if you're working on suppose if you're working on I can say herbal toothpaste or a herbal hand sanitizer or herbal soap or something, some herbal product, and or some research work, you have used the herbs, and the herbs have been procured from India. Then you have to specify from which region you have procured that. Okay. Suppose cardamom, we are using cardamom. We have to specify whether we took it from Ooty or that is Tamil Nadu or from Kerala, where whichever geographical location you have collected it, you are supposed to specify the location and you will have to seek the permission from National Biodiversity Authority. The reason for doing that is, okay, the reason what we have to do for it is, you'll have to specify it is again the asset for the nation. You are saying that such good cardamoms are available from Kerala. Such good cardamoms are available in Tamil Nadu. So they will get a survey, a report from where we're using it, and that record should be there. That is why we should do this. So when your patent is related to herbs, we have to file this. And also, this comes into picture only when we go for examination. If you are just interested in publication, you need not have to worry about this NDA. Yes, ma'am. I have a question here. Let me answer that. Does the NBA approval apply to microbes also? Yes, ma'am. So, type of application here we have. What is that type of application here we are going to select here? Since we are just going to apply for a research work for the first time, we will select it as ordinary application and we are going to proceed with it. So here you will have to select the type of application, whether it is provisional or complete. Okay. Then you have the complete or provisional specification. So number of pages. This is the description part. As I said, the description part you'll have to specify here, and the claims you will have to enter the number of claims and number of pages those claims are occupying. The number of pages of abstract, actually it will be usually one, because they are limiting, they are asking us to limit the number of words to 150. So the abstract page will be one only always. And also next we have number of drawings. Okay, number of pages in drawings. So, and one more thing, number of drawings, that means number of figures. Suppose you have put 5 figures in 4 pages, specify 5 here and 4 here. So that is how you are supposed to specify. Okay. So if you have any priorities, this will come into picture if you have already filed some application outside outside India, that is in other foreign countries, other patent offices, and you are now applying to it, means in such cases it will show the priority documents you will have to add. Otherwise, it doesn't come into picture here. So please put your title of invention. Please put the address for service in India. So here, if you give your agent address will come, and their details will come. You will have to keep your document open, copy paste the abstract, description, claims. Then applicants will have to add. If the inventors are same as applicants, just click on it. It will display the same. And here, if you click provisional, 1 second, I'll show you. Okay, this box will be automatically selected, otherwise complete. So this you will have to check before saving whether it is provisional or complete. So you have to be very careful here. And then you will have to here nothing you have to select, just give agree and save. So this is the form. If you have any doubts in this form, you can ask me. I'll just wait for 1 minute. Does anyone need a break here, or shall I continue?
You can continue, ma'am.
Okay, ma'am. Okay. Then I'll wait for just 1 minute. If they have any doubts in this form, they can ask me.
Okay, ma'am.
Yeah. Very nice question, sir. So jurisdiction means it will be automatically assigned once you enter the address for communication. Okay. The reason is like first applicant's address. Depending upon the address of the first applicant, I'll show you. So this has to be entered. So applicant name, you will have to enter the applicant name here, their address and all that will come here. Okay, this is, if it comes, depending upon the address, it will put the jurisdiction office here, whether it will come under Chennai or whatever it is, it will just select here. Suppose it is from any of the 5 of the south states, the jurisdiction will be Chennai only. And like that, if it is somewhere around Pune and all these places, it will come under Mumbai Patent Office, and some like West Bengal and all that, Assam and all will come under the Kolkata Patent Office, and for Odisha, Rajasthan and all will come under what we have, again they will come under Delhi Patent Office. So this is how they have divided. So it will be automatically selected based on the address what we give here of the first applicant. So I guess it's right. The like what type of application number for design patent? What type of application number for design patent? Yeah, you will get something like a 6-digit number which will start from 3, that is the sequence, and you will have -001. Okay, then it is a design patent number. Yeah, Nikita ma'am has given the number has 3555057-001, and she's asking whether it is right. Yeah, ma'am, it is right. That is how the design patent application number will look like. So 3555057-001. Okay. Lokesh sir, I guess it is clear now. So depending upon the location of the first applicant, it will take the jurisdiction automatically. So yeah, this form is done. Let me explain the form 9. So this is how form 9 looks like. You'll have to put the application number for which you are going to request for form early publication, submit. You will get your form, save, upload it and get it done. So form 9 is up, and form 18, let me show. So request for examination, put the application number here, submit, you will get the form and you're going to check for it. Next. Okay, all forms let me go to. So as I said, form 18A is for request for expedited examination. So faster examination, you will have to fill in this form. Okay. So 28, let me show. You'll have to put the application number here and validate, and it will give out the application that has to be filled. Next, what forms? Okay, let me show. Form 3. Let me take one example and show you form 3 first. Okay. Form 5 is declaration. Form 9 also, as I said, it is for request for examination. Okay. And you can reply to examination report here. So here you'll have to select what you are doing to. So we are responding to FER or ACR. Here we have two options, with fee or without fee. What is that with or without fee? With fee means, suppose you are not able to respond within 6 months of time. We have some deadline, right? And within that deadline, suppose some circumstances didn't allow us to respond to the FER within that specified date. At that time, you will have to request the patent office to extend the time. For that, you will have to fill the form 4. Form 4, I'll tell you. Once again, let me show form 4. Form 4 is for extension of time. So time extension for anything. So you'll have to delay. That time you'll have to request this and put the application number and request the controller to extend it for some more time. So that is what you will have to do in this thing. So form 4 is there to extend the time. And if we have extended the time, again, your response cannot be submitted for free, without fee. With fee only, you will have to submit. So you'll have to select with fee there for the response, and you will have to submit your response there. So renewal of patent can be done here through my icon. So I'll put the application patent number here, and I'll submit and I'll renew it. Okay. So next important question. Somebody have a question here. It is not able to do without DSC, or yes, without DSC it is not possible. As an individual, can I file? Yes, you can file, but the patent only for you can file, not for others. So if you are an inventor, if you're a true inventor, if you feel that you can do it, yes, do it. But please follow all the rules and regulations, do the draft and keep everything ready. Just because you have the DSC, you can't file it. But it is possible if you are aware of the rules, if you are aware of the patent documentation format, then it is possible. What is the use of filing it without any format? Again, it is waste. Nobody can get to know whether it is done or not. Even for the publication, it will go or not. Even we can't even guess that. So please be careful about that. So that was the question I answered from the comment session. So that is done. So here again, okay, ma'am, how many months will they take minimum for FER? Fine. To respond to FER, sir, they may take up to, if it is a normal case, I'll tell you, if we are requested for examination without any exhibited thing and we don't come under any categories, concession categories, at that case, they have time to dispose it up to 3.5 years of time. 3.5 years time they can take from the date of request to dispose our application. So, and if it is early examination, 6 months of time. Within 6 months of time, they will dispose the FER report. So this is the timeline for FER. Okay. So this is clear here. How renewal of patents and all that are very clear. So this is how my login will look like. It will be the control panel. So it is for updating my personal details like password and all that. So this is how it looks like. So is this clear? Shall I leave this form? Shall I log out of this and show the form 2 format, how I have done it? Okay. Wow, I have one more interesting question here. Ma'am, can we file a patent of concrete mix design? Sir, I'll have to look into what you're actually claiming for. If it is a device, if it is a mixture kind of a product, a device you're done, then we have to go for design patent. If you have done a concept where the concrete mix will improve the efficacy of concrete mixture or the strength of the building, or it has much more advantages than the existing concrete mixes, then we can go for filing a utility patent for it. So I can answer to that question, like exact answer can be given only after viewing your abstract or synopsis, I can say. But with this question, I can, if since the question includes concrete mix design, I'll have to see whether it is design patent or utility patent. If that is clear, I can answer. Okay. So now I've just come out of the e-patents filing thing. So one second, let it load. I'll show you the design application, how it will be filed. Okay. So here e-filing trademark, e-filing designs are here. Okay. Let me log into design page. Yes, ma'am, we can file a patent for medical procedure. There's a question whether the medical procedure can be patented. Yes, it is possible to do it. One second. Yeah. So this is how it looks like. We'll have to fill the form here. Quick form filling, new application. So you'll have to select the class. For this, we have the own dictionary for it. So we'll have to study that and we'll have to decide under which your product will come. So based on that, you'll have to select here. Then you'll have to enter the applicant name, applicant type, address, country, nationality, and such things. All the information has to be filled. Here you will have to upload the applicant and here you have to upload the representation sheet, what you have prepared for your design document. Save it, declare, that's it. And it will be available under drafted forms. So this is the application. This is how. I don't have any already drafted documents here. Maybe in discarded form, if I have any, I can show you. Okay. Here you have to make payment and all that is similar to that. Here you have no different forms you have. Actually, it will only this form will be much useful for us and nothing else will be into picture. Okay. So this is how. Let me sign out of it. Okay. Here I have explained almost everything, e-filing and here publications you will get it here. And if you want to know more about the Patent Act and laws and all, I'll let you know where you can download the things from. See, acts and rules. If you go here and download, you will get to know what is the, once again, okay, acts for patents. If you download, you will get the patent acts. Rules you will get. Design act you will get. Design rules you will get. You will get the manuals for patent design filing here and guidelines also here. So if you go and check here, you will find all the details. So I can just show the acts. So you'll have to download from here and it will show what all has been happened and what are the laws and what are the sections which are we are eligible for and all such things. You can read it and you can analyze it. And this contact us page will give you the different patent office numbers and the controllers of all the patent offices will be listed. Okay. So any doubts still here? So have done with e-filing of patents and designs as well. So IP office website we have taken and we have done it as an example. Now FER copy also I have shown you. Now I can show you one already filed, one second. I'll show you. Okay, see this. This is the form 2. This is how my form 2 will look like. Here, the preamble, as I said, for the complete specification, it will say the manner in which it is performed. So it includes the field of invention. This is what I say as background of invention, where we will be putting the already available document. So the patent number I have put and I've explained. Okay, so this is how I've explained the things here. And summary of invention. Brief description of drawings. As I said, it will describe the figures that will be included. Okay. Claims. This is how the claims will be numbered and explained. And finally, the abstract comes. And every page will be digitally signed by. So this is how your form 2 will look like. Okay. What is, okay, drawing sheet, let me show. This is how my drawing sheet will look like. Okay. Even this will be digitally signed. Okay. How my form 1 will look like, I'll show you. Submitted form 1. After I fill in the form, when I download, this is how it will look. The applicants, inventors, my phone number. Okay, again, I'll have to digitally sign here. And what all I have uploaded. What all I have uploaded, form 1, complete specification, and drawings are what I have uploaded. This is how it will look like. Okay. So I'll show you one of the representation sheet of drawing so that you will understand how the this is for already filed concept. So this is how the representation sheet for a drawing will look like. That form 2 is for utility patent. Okay, the document of design patent will look like this. Minimum 6 views we will consider: top, bottom, left, right, front, and back. These are the views that will be considered. So, one second. So, we have a POA, which will be in this format, where they are authorizing me that I'll have to. This is for Reva University, what I have done. So, they have authorized me as the patent agent to continue for filing that design patent. So, this is the format of POA for design patent. So what else I can show is the form, right? Yeah, I can show you the form of design patent. So one second. This is how the filled form of design patent will look like. So I have selected the class, the article title, the applicants, that's it, and the declaration. It is very simple. And I can show the FER report. Okay, that is the response. FER report, I'll show you if possible. Mm. One second. Where is it? One second. I'll just see if I get any form and I'll show you before it. So, any other questions I have? I'll be taking a break of just 2 minutes. I'll just pause for 2 minutes. I'll have some water and I'll be back.
Okay,
Is
ma'am.
it fine, ma'am? Is it fine?
Okay, ma'am.
Okay, thank you. I'm back. I'll be starting the session again now.
Yes, ma'am.
Okay, I guess screen is visible now. Yes.
Yes, ma'am.
Okay. So let me show a document. Okay. This is the design document. Like the FER, what I showed previously was for the utility patent, and this is for the design patent. Okay. So this is the design patent. FER. They will say what are the objections, what we are supposed to submit, and all such things will be. If they feel that the nature of article is not clear from the representation sheet, we are supposed to explain the purpose or use of the article so that they can distinguish that it is unique. Okay. So that's good. Let me, okay, fine. Then I have something I wanted to show one more thing. So design, we know how the representation sheet should be, and we also know for utility patent how it should be. I'll just explain the timeline chart because they had a doubt on like they wanted to understand the clarity on how to do the thing, right? So let me explain it once. So the chart is very clear again now. Since they wanted to explain the examination process, let me explain it through a chart here. So filing of application, publication of application promptly after 18 months or early means within 1 month. Request for examination. So within 48 days from FD means from the date of request filed. So examination issue, FER will be issued. So we'll have to represent if there are any objections. Suppose if you, as somebody said, what if somebody else is taking my idea and if I feel that they are copying it, go for filing an objection within 12 months of time. So once it is published, it is represented to the public. You can just go and raise your objections within 12 months of time. So grant of patent. So within 12 months, again, opposition will have to be represented and decision of the controller. If in case you have any doubt about the decision of the controller, kindly go and appeal to the appellate board who will revoke the decision given by the controller. So this is what happens. So next, let me tell this for the copyright procedure because I explained about design and utility, and let me explain about the copyright also. So filing of, and one more thing I'll make it clear, a patent agent for trademark is different from the patent agent for patents, designs, and copyrights. Okay, a patent agent can file for copyright, designs, and utility patent. But to file the trademark, again, they'll have to clear the trademark agent exam to file for trademark. So make it that point, I just want to share it with you. So here, procedure for filing, copyright application, filing of application. So you will get the number in 2 or 3 weeks. Then the examination of application will take about 6 weeks time. Okay, if there is some non-compliance, some objections, then it will be communicated to us and we'll have to remove the objections. If in case the objections are not answered, it will be abandoned. So compliance with objections within 30 days of receiving the report, then they will re-examine it once we have addressed the objections. It is accepted or rejected. If it is accepted, they will issue the certificate of registration. So this is the procedure for filing the copyright application. So I guess it is very clear. So ma'am, let it have this session for open questions because I have said everything from morning. So if they have any doubts, let them clarify their queries. Is there any queries?
Thank you, ma'am. I hope all the participants have gained an appreciable knowledge on patent filing and drafting through this highly informative workshop. If you have any queries, you can ask. Ma'am, there are few queries in chat box, ma'am.
Yeah, I'm just going through them. So can you tell the need for Form 27 of granted patents? So Form 27 is like working of statement. So once you have started commercializing your product, then you will have to furnish the detail regarding where you're using it, where you're going to license it, and such thing will have to be filled in Form 27. Form 27 will come into picture only while your patent has been granted and you are commercializing the product. So you'll have to keep informing the patent office about the status of the granted patent. That is nothing but Form 27. So I hope it was like at least you could get to know like how we are going to work on what all IPR thing you can concentrate on and how to apply and all that. I guess I've given a insight into it.
Thank you, ma'am. Please send your queries regarding this session to the email ID. We will reach you as soon as possible.
Actually, Avinash sir had shared his concept and he wants to know whether we have to file a utility patent or not. I don't want to disclose his idea, but I'll say that yes, we can go for filing a utility patent based on the information which has been shared by Avinash sir. I can say that. So we have anything else apart from it? Okay, ma'am, how to check for prior art search on trademarks? So on trademarks also we have a separate login where if we file, we will run a form and it will just give us whether something already related to that name or the design of the logo already exists. If there are such things, it will display us in the run form as results. As we do a prior art for the, as you said, as we do a prior art, we will check for the documents there. Here we will check for the logo and the purpose of the logo, like the nature of the business, I can say. So in the trademark, we will look for the nature of the business, and if it is not same and if it is convincing, we will get to know whether we will get a thing from patent office or not. At that time, we can do that. Based on that, I will say whether the trademark is possible or not. So anything else we have? Why I give much time for the interactive and queries is because I have so the procedure I have explained. See, only when people ask doubts, when I answer to those questions, a layman's knowledge about patents will be improved because sometimes they may have the question and they may not come up to ask for it. Only if it is asked, it is clear. So I'm just giving much time for the discussion rather than just posting the slides and keeping the information on PPT, because whatever I have to explain on PPT I have done and I've already taken your time. So it's post lunch session. Let it be interactive.
Ma'am, yes, ma'am, fine, ma'am. Hello.
So any queries if you have?
Ma'am,
Or
Gautam, ma'am, what's our ma'am? Hello.
hello? Yeah, Anand. I will do that. I will do that. Okay.
Okay, ma'am.
So any queries? I had already had queries regarding like how to contact us and all that. So as I said, we have displayed in our slides. One second, I can just show you. Okay, you can note down a number. So anytime you can contact us for support. 1 second. So this is our contact number. So you can contact us at any time.
All the participants' mic is unmuted. You can ask your queries.
Hello, ma'am.
Yes, sir.
Ma'am, I have a doubt.
Yes, sir.
We want to apply some pattern in different application fields. Say, for an example, in cricket STEM, they have already gotten pattern, right? If
Yes, sir.
the multiple of application, we can in the multiple application we can apply the pattern in one form or at a time, or we have to get in separate things, separate forms.
Okay, so I'll ask some few questions. If you make that clear, I will be able to answer for this question, sir. Sir, if
Sure,
you're
sure,
asking the same technology divided into different parts
not
or the same
same
area of
technology.
work?
But say for an example, I have I am having an application in cricket STEM. The same thing in little modified the places has been differ for an bills or bat or pad like that.
So
That
what will be
technology is
the
technology is the same thing, but the
okay?
thing the use of application is different. So we have to get a pattern application in different format or in one format we have to get in all those things.
Sir, I'll
That's
tell
what my
you.
question.
Okay, if you have, suppose if nobody else have already applied with the same technology, you are modifying some, okay, everything related to bales of and stump of the thing you are working on means, then you can, in a single application you can go for it. But since you are saying it is already existing, only thing I'm doing is I'm just giving the variation to it, means different application of it, same technology but different application, then we can't go for a patent. You can try for a design patent, but utility patent is not possible in such case.
Okay, ma'am. Suppose if I am the one who got the pattern means I can go
Then
for
you have,
different.
if you are the prime applicator who have already applied and you have given modification, you have all the rights because you have the priority. So you can proceed with that, sir. That's not a
So
matter.
I can get a different number of patterns. So 1, 2, 3,
Yes,
4 like that from patterns.
yes.
Not in the
That will
one
be not in one means,
not
sir.
it
How many
counted.
days?
No, what I mean is if the number of applications differ for say for an example 4 or 5, 6, 7, 8, but it could be counted as one pattern or that
No,
number of.
no. Only if you file it as divisional application, then it will be considered as one patent. If you are filing it as separate patents, you can only claim that you have already got grant or you have already applied that, but you can never consider it as a single patent.
Okay, understood. Thank you.
Okay, sir. Thank you so much, sir. And here I have one more question. So let me see that. If we have an instrument or device made to check currents.
Good afternoon.
Sir, here for this question, Harvinder sir said, since I feel that you have given the technological aspects also into it, it is better that we cover up with utility patents, sir. If you're concentrating only on the device, then for the device we have to go for design patent for the instrument, and for the technology what you have implemented to get the device done, we can even apply for utility patent. So it sounds really good, and we can go for both in that case, sir. I hope your question has been answered, sir.
Yes, ma'am. May I?
Do we have any other
Sir, Jan sir. Hello. Jan sir, is it audible?
ma'am? Yeah, ma'am.
Actually, thank you so much for your very knowledgeable presentation, ma'am. I had a query that if we have a this medical procedure one, so in
Yeah.
that case, we'll go for which type, direct patent or publication patent, design patent or publication patent?
First step is publication. Without publication, we can never proceed. So first step, apply for a patent, get it published. And after that, if you feel that your concept is totally ready without any flaws, we are fine with it. We will request for the examination from the patent office and proceed towards grant.
Okay. Then it is same for software also. If it is a software
No, ma'am.
based
No, ma'am. Software,
any technique.
ma'am, software cannot be patented. The software or the computer algorithms
Like
can only be copyrighted.
like because in today's because we are working on AI and ML techniques, like, and we have
Yeah.
designed a certain
Okay.
procedure for suppose on a medical concept. Okay, so can it be patented or it cannot be? I just wanted to know.
Ma'am, it can be. Since it is, ma'am, algorithm has been embedded with the hardware component and we are going to show some results out of it, right? So we are
Right,
embedding
right.
AI module into a hardware component and we are trying to show the efficacy of our results. So in such cases, it is
Yeah,
possible. In such cases, it is possible to go for utility patent. So your as you said, ma'am, your medical procedure with the diagnosis device is absolutely fine to go for a
Mm.
patent.
Okay, okay. Thank you so much, ma'am.
So you can
If
anytime
you
you
have
can
any
contact me.
queries, yes, yes. Okay, thank you so much.
Ma'am, the number has been displayed
Hello.
there. If you contact them, they will let me know. Yeah. Hi. Hello,
Hello,
sir.
good evening.
Yeah.
Is
Can
the
you hear me?
procedure whatever you said that
Hello.
ma'am, is the procedure for everything only for the medical thing, as you said, the publication is first and then we go
No,
for
no,
the
no.
grant?
No,
Only
no,
for
no,
a
sir.
medical or all that field, electronic?
Every patent, as I said, I have showed the chart of it, the flow of patent application. Once it is applied, the very next step is publication. Only after publication we can go for request and then the grant of it. This is how it flows. Sir, as far as the academic purpose is considered, and for just commercializing the product, I see publication is more than enough. To get the product granted is like you want to export it and all such things. And for a recognition and grade that you own a patent, you can say the granting of patent. Publication is enough to commercialize the product. So publication is very first step of it.
Thank you.
Sir.
Thank you, ma'am. Now we'll go ahead with the conclusion function. I would
Okay,
request Professor Praveen PN Sir, Associate Assistant Professor from the Electronics and Communication Engineering Department, to start with the welcome address. Over to you, sir.
Hello everyone, myself Praveen, Assistant Professor ECE Department, Tijon Institute of Technology. A very good evening to everyone gathered to the valedictory function of one-day international workshop on international and national patent drafting and filing 2022, organized by Tijon Institute of Technology in association with Indosense Research Center, Tamil Nadu. I have been assigned the duty to deliver the welcome address. It is a great pleasure for me to extend hearty welcome to today's chief guest, Dr. N. Yuvaraj, Regional Manager, Indosense Research Center, Tamil Nadu. We are happy to have you here, sir. Thank you for accepting the invitation. I would like to extend warm welcome on behalf of the institution to our reputed chairman, Dr. Thomas P. John, Tijon Group of Institutions. And I would like to extend warm welcome Mr. Roy M. Raju, Administrative Officer, Tijon Group of Institutions. Next, we have the Campus Director, Dr. T.D. Kemberaju, Tijon Group of Institutions. Hearty welcome you, sir. With immense joy, I would like to welcome our most motivating and beloved principal, Dr. P. Suresh Venugopal, for this gathering. Welcome you, sir. I need to welcome Mr. S. Anand, Managing Director, Indo-Essence Research Center, Tamil Nadu. And we also have with us our Vice Principal, Dr. H.P. Srinivasa. Welcome you, sir. Head of various departments, faculty members, research scholars, and last but not least, the delegates from various countries to this validatory function. Hope this function will be providing or provided two informative conclusions to everyone. Thank you.
Thank you, sir. Now I will request our principal, Sir Dr. P. Suresh Venugopal, sir, to address the participants. Over to you, sir.
Good afternoon to one and all who are present here. I think from the morning we had a very good session related to the design drafting of the patent and filing part of it from Ms. Gautami from InterScience Research Group. In the absence of our principal sir as a busy schedule, I'll say thank you to the organizing team as well as the association InterScience Research Group for such kind of a wonderful session. From the morning, we are seeing that most of the participants have utilized, they have asked the queries. I think most of them might have got it, the answers, feedback. So this is one of the program which we have successfully ending over here with ample of knowledge which we have gained. Thank you. Thank you all.
Thank you, sir. Now I would request Dr. Yuvraj, sir, to conclude this session.
Good evening to one and all. Am I audible, ma'am? Hello.
Yes, sir. Yes, sir. You are audible, sir.
Yes. Thank you, sir. Thank you for the confirmation. And I'm good evening to everyone. I thank I thank the institution of T. John Institute of Technology for having this wonderful workshop session and for gathering and for providing all the facilities for conducting this workshop. And I would like to thank my more humble to Dr. John, R&D Cell Coordinator of Associate Professor, who help us, Department of Computer Science, who help us to conduct this workshop in this prestigious institution. But based on his input, we have started working on this workshop, and we started groundwork, and with this enormous amount of support, we have done this complete workshop. Obviously, Dr. John sir also has published several patents and publication papers in his research domain. And I would like to thank the chairman sir, principal, vice principal sir, for providing the support for conducting a workshop. And I would like to thank the resource person, our ma'am, Gautami ma'am, who provided in and out each and every points and how to from the scratch of patent. Today, most of them are, I hope most of the candidates, viewers who attended this workshop are in a freshers stage. So from the initial stage to the publication stage and the grant, on how we can approach and how we can submit our documents for getting the grant. She provided more amount of details and further aspects for this workshop. And I hope this workshop will provide a better clarity, and I wish that most of the researchers professors can submit their ideas and aspects for getting more amount of patent publication, so that it can increase our profile as well as personal profile and also institution profile, and it will make us our country more growth and higher standard aspect. And last but not least, I like to thank our manager Anand sir for his enormous amount of support. Based on his input and the Gautami man's support only, we started this organization and we started working on this aspect. So based on their support, we started working, and we are looking forward to have a more amount of future programs with our institution, and also we would like to conduct more amount of workshop. And I hope with this workshop, the output will be, we are expecting that a number of patent publication will be happen in future aspect. If any queries or any suggestions or any feedbacks to be given for our improvisation or in terms of handling the workshop and suggestions, you can drop us a mail, which Gautami ma'am has shared during the presentation. And once again, I like to thank all the audience, faculties, professors, and institution for this workshop. Thank you, sir. Thank you all.
Thank you, sir. Finally, I would like to request Dr. Divakar TR, sir, Research Coordinator and the Assistant Professor from the Department of Chemistry, to give the vote of thanks. Over to you, sir.
Okay, thank you. I am Dr. Divakar TR, Associate Professor and Research Coordinator, Department of Chemistry, Tejan Institute of Technology. It is my pleasure to deliver the vote of thanks. I would like to thank today's resource person, Ms. Gautami S., Indians Research Consultants Private Limited, for delivering a beautiful session on patent drafting and filing. On behalf of Tejan Institute of Technology, I express my sincere gratitude for the beautiful session. I also thank Dr. N. Yuvaraj, Regional Manager, Indocence Research Consultant Private Limited, for his valuable support and cooperation with Tejan Institute of Technology. I also thank Mr. Anand MS, Managing Director, Indocence Research Consultant Private Limited, for his constant support. I thank Dr. Thomas P. John, Chairman, Tejan Group of Institutions, for his constant support and encouragement. I extended my sincere thanks to our campus director, Dr. T.D. Kemparaju, for his valuable suggestions and feedback. I thank the administrative officer, Mr. Roy M. Raj, for his support. I extended my thanks to our beloved principal, Dr. P. Suresh Venugopal, for his constant support, encouragement, and valuable suggestions. I extended my sincere thanks to our beloved Vice Principal, Dr. P. Srinivas HP, for his constant support, encouragement, and valuable session. I also thank the R&D Cell Coordinator, Dr. John, for materializing this program. I also thank Mr. Praveen, Associate Professor, Department of ECE, Dr. Soni, Assistant Professor, Department of Physics, and other members of R&D cell. I also thank the Student Coordinator, Uma, Department of ISC, Anusha, Department of ISC, Ruchita, Department of ISC, for their contribution towards the success of this event. I thank all the teaching and non-teaching staff of Tejan Institute of Technology and all the participants for spending their valuable time and energy during the course of this session. Last but least, I thank one and all present here on behalf of Tejan Institute of Technology and from the bottom of my heart to make this event a success. Thank you and Jai Hind.
Thank you, sir. Participant will get the certificate in 7 working days. Please fill the feedback form in the chat box. And copy and paste the link again. Please everyone stand for national anthem. Thank you everyone. The link is given in the chat box. Please fill the feedback form. You'll get the certificate within 7 working days. Thank you.
On behalf of Tijon Institute of Technology, I thank all the participants who are part of this workshop. Thank you one and all. Manikanta, John sir, I think we can end the meeting. John sir, Manikanta.
Listen.
Manikanta, end the meeting, then download the attendance, download the recorded video.
Okay, sir.
Okay. And one more thing.